Hey folks, it's time to get into it. So before we get started with our first section of law today, I want to make sure that we're up to date on what the plan is for the investigation. So we are about 3 weeks away from today, 3 weeks away from today when the investigations need to be complete. And so there's a few things about protocol that I wanted to talk about, as well as some plans for what's going to happen in 3 weeks once the investigations are done. So first and foremost, with respect to protocol, if you have not reached out to your to the person whose fraud you're investigating right now, you are behind. Okay, so do not do that right now because we're in the middle of a class, but please do that as soon as possible once class is over. And you should be consistently reaching out unless you've solved the fraud, unless you're confirmed, you've confirmed all 4 questions and feel like pretty solid that you've finished the investigation. Your inquiry should probably be on a fairly close to daily basis. To that end, okay, I have heard some stories about people sending pages of questions as immediately as the first response. I do want to make you aware that while I appreciate the enthusiasm, that keep in mind that the people that you're working with, they have their own personal responsibilities they have to meet. And so if you are over enthusiastic, and I'd rather you be over enthusiastic than under enthusiastic, but please keep in mind that the time frame is going to be pretty close and pretty tight. Please be conscientious of other people's times when you're sending questions. If you're sending 5 questions when 1 question will do, then send 1 question. I respect that there's a delicate balance there, that on one hand I'm telling you start asking questions now, on the other hand I'm saying stop asking so many questions. That really kind of contradicts. Please be just consistent with your questions. Maybe 1 or 2 a day is probably fine. 17 every hour is too much. 1 every 3 weeks is not enough. Okay, so somewhere in the middle there. So what is going to be the presentation? What is going to be the end result? So once you have turned in the results of your investigation, which is your 3rd deliverable, everybody will be presenting during the final week. Basically, the format of the presentation will be like this, is that everybody will get up here. You will do a minor presentation. It's going to be kind of similar to the 3-minute thesis competition that we did back in AIS, that format, where you basically will present the results of your investigation. You'll have basically around 5 minutes to present, and then the person whose case you're investigating will say, all right, did they get everything? And hopefully the answer will be, they got it perfect, 100%. And the response will not be, they missed about half of the fraud. All right, so if you missed about half of the fraud, will that affect your score? Yes, it will. Okay. That's not the only thing that's going to affect your score, your grade. If you are not, if I review and say that there was not a consistent stream of communication, the communication was muddled, you were not asking relevant questions, stuff like that, that's going to be affecting the grade. So please keep that in mind, that you are being graded not just on your level of effort, but how effectively you actually finish the case. I will say in my review, some of the cases are going to be more challenging than others, and I respect that. That's just a matter of variance. Can you get full credit if you don't solve the case completely? Absolutely. If you put in a sufficient effort, then you can get full credit. Can you get less than full credit if you do complete the case? Complete the case. The answer is absolutely. If I think that you did minor amount of effort, but you just got lucky, then I will reflect upon that. I keep in mind everything that in this course does reflect upon your not just your knowledge about stuff, but also the effort that you put into it. If I think your presentation was kind of phoned in and you just managed to find the fraud through happenstance, then I will be very blunt and honest and say that. So I want to make sure that you demonstrate not just the effort in your presentation, but the effort in your investigation as well. Last note on that. If you go to week 15 in the assignments tab on Brightspace, you will notice that there is a new link up there. It's the fraud scheme investigation presentation sign up. This was actually a request that I had not put up. I'd done it for another class and forgot to do it for this class. We will be presenting on Tuesday and Thursday. So there's 20 people in this class. So that's 10 presentations each day. So you can go ahead and start signing up. You will need to sign up through Google Forms and use your Truman State account. If you try to sign in with your own personal Google account, you won't be able to get in. So please make sure you start thinking about that when you want to present Tuesday or Thursday. If you don't have a preference, then you can wait and let everybody else take that preference and then fill in the blanks. But that's just something, if you want to start thinking about that. There's only 2 dates because we only have 2 class periods per week for this course. So that's going to be what we need to do. All right, starting law this week. And we're going to be reflecting back on some things that we've talked about before, introducing some new concepts. So this is something that when I was trying to figure out how we're going to structure this course, I went back and forth on saying whether or not this needs to be early or late in the course. Optimally speaking, I think that this should probably be a much earlier section of the course. That being said, it is the most boring of the sections that we're going to be covering because it's law. I mean, who likes lawyers? Anyway, when I make a joke about that, I do know that you have some exposure to law and some of these concepts we've already talked about. I'm assuming that because we do have a couple of very good attorneys that are on the faculty that they've taught you these legal concepts. So most of this is going to be review as opposed to new information. That being said, it is going to be important to reflect upon this information, understand how it relates to forensics. And so let's go ahead and get into it and make sure that you all are on the base that you need to be and have all the basic knowledge that you need to understand to be able to use this in a prosecution context. By the way, just for note, our week 14, our schedule is a little bit different. We're going to be doing the law section of part 3, but we're not going to be doing it all in one week. So part 3, we're going to start on Tuesday. Then the following Thursday of week 13 is basically the student research conference. And so we're not meeting on the day of student research conference. We will not complete law until the following week, which will be week 14. And then our final class session before week 15, with the Thursday of week 14, we are actually going to have a lawyer, a healthcare compliance lawyer who worked in forensics, presenting to us. And so might be interested in taking notes in here. And if there's anything that comes up, it's like, I wonder how this works in practice. That would be a good question to ask our visitor who's going to be presenting to us on Zoom for that particular presentation. It's because one of the reasons I asked him to present at the end of this is because we will be finishing up law at that point. And he's an expert in that, being a lawyer, which I don't know. I'm a little bit ashamed to say that I've got friends who are lawyers now. So yeah, as much grief as I give lawyers, you think, yeah, it's just boo. Yeah. He was actually my mentor at KPMG, and so he'll have some stories for you, and I'll have some stories for him. So it'll be great. It'll be a great time. And you guys are free to officially ask near the end of the presentation, not at the very beginning of the presentation. Do you have any embarrassing stories about Barnes? Okay, and he will basically, the floodgates will open. The floodgates will open. All right. First resource identifies 4 general types of legal systems. Common law, civil law, religious law, and customary law, provided a brief description of each type of legal system and which one's present in the United States. So I got my notes up here. So, oh, Tyler, you're the first one up. All right. Are you excited? You stoked for this particular question? All right. Well, lay it on me. What are they, and which one's present in the United States?
Legal precedent created by the judges. The statute of laws was created by the legislature. Civil law is created by the legislature, but not the judges don't follow the precedents and religious law based on religious text and interpretation of those texts. Customary law is like tribal at the local level and district. So it varies place to place, community to community, and then the U.S. practice common.
Yes. So common law, the one that's practiced in the United States, the way that's kind of defined in the first resource, basically as Tyler said, develop judges through case-to-case court decisions, and is established a concept called precedent. We actually talked about that in a seminar on auditing a little bit, and I said, well, we're going to talk about this more in forensics. Here it is. But precedent basically says that if we've got a decision that was rendered in a court of law, we can use that decision as a determination for future legal action. So if we find one situation that this particular action was illegal, that sets a precedent for the future. And the precedent says that if it's legal in one situation, it's legal in all situations. If it's illegal in this situation, it's illegal in all situations. That's an oversimplification. I will say that the United States legal system is a little bit more detailed than that. You can't necessarily apply all precedent in every single situation because circumstances will change in different court scenarios. But for the most part, it does operate in precedent and says that here's the example that we're going to use as our defense or our prosecution for this particular scenario, and that is going to be the precedent that we established. Now, civil law, again, places greater emphasis on legal codes crafted by the legislature. Now, that does not mean the courts don't have any say in that, but civil law tends to be more established by a higher level legal thought external to the courts. Okay. They tend to be updated continuously, and then when they're managed before the court, they basically are going to be established according to what was been set forth by not precedent by the legislature itself. Now, this one is kind of a little bit more subtle. This is a distinct law system that is present in, I believe, the Southern European courts is kind of where we see most majority of that. So Spain, France, Italy, I believe that those are all civil law systems. And there's not a massive distinction between that and common law court systems. But one thing that's important to note, and this is something that's very relevant to us here in the United States as accountants, is that civil law oftentimes is more about interpretation of what has happened in the past or interpretation of what the law is in a given scenario. So precedent, we say, here's what happened. It was rendered illegal in this scenario. It's illegal in all scenarios. Okay. Civil law says, here's what happened in a previous scenario. How does it apply in a given future scenario, and what are the differences that might make it different? So remember, we talk about accounting. We talk about the rules of accounting in the United States, and we say that accounting is based on rules in the United States because of legal precedent. The same kind of holds here. We talk about European guidelines. They're principles based, and principles based is more about interpretation of a given scenario than an application consistently across all scenarios. So very, very similar concept when we think about generally accepted accounting principles versus IFRS. Then we talk about civil law versus or common law versus civil law. Then we have religious legal systems, which are generally not as present. They still exist in some areas, particularly in the Middle East. They do exist, but they're not as established as they used to be. And this is basically the rules are based on religious text and interpretation of those texts, which is certainly can certainly create some conflict given some of these texts are thousands of years old and they don't really address common modern day scenarios. And I don't want to really get into depth on that because it tends to bring people's faith into question, which is always a bad path to go down in any scenario. But yeah, when we talk about religious text, it is trying to interpret modern day scenarios given classical architecture. Tends to be problematic, which is why it's not utilized as much or frequently anymore in the world. And then customary law is kind of similar in context. It's more about what's found at a kind of village or tribal level. So the customs that have been established, they set the same type of precedents that we see in common law, just tends to be a smaller area and smaller realm of rules and capabilities. And these are established kind of based on observations and things that have happened in the past. If you think about what we would think about a tribal law, it's like, okay, if you leave the village, you're an outcast or something like that. It's kind of a simplification of tradition or the way we traditionally think about laws, but it's simplified because they're simpler scenarios. And so customary law, very, very minimally used. You can actually see it in some lesser developed areas of the world, but for most of the more developed areas of the world, customary law has kind of been gone by the wayside. So yeah, important to note. We'll get back to that here in just a little bit. According to the ACCT Fraud Examiner's Manual, fraud may be prosecuted criminally, civilly, or both. Okay. So briefly explain the difference between criminal prosecution and civil prosecution. Holden, what you got?
For criminal prosecution, government at the state or federal level files charges against a person or entity with the aim to penalize unlawful behavior through fines, imprisonment, or probation. The prosecution must prove guilt beyond reasonable doubt. And then civil prosecution, individual, business, or government entity initiates legal action against another party for violating civil rights, usually seeking financial compensation or specific remedies rather than punishment.
Yeah, so there's a couple of important distinctions to make there that Holden alluded to. So probably the most important distinction is that what is the goal, what is the objective of the particular action? If we're talking about a criminal action, that's basically to punish somebody for violating a law. Okay, so you are speeding in front of the university, you get pulled over, you get a ticket. That's a violation of the law. You get a punitive assessment associated with you. Okay, so punishment associated with that. For civil action, it's more about a wrongdoing against an individual or group of individuals and seeking remediation of that. So You were speeding in front of the university, and you mowed down one of the accounting professors. Okay, so they sue you in court and say, I can no longer teach forensics or auditing. You're going to have to pay for my livelihood in the future. Okay, that's more of a civil action. It's basically saying you had wrongdoing. You're responsible for the injuries I suffered. You have to actually pay for that. And so, yeah, that's one distinction. Another distinction that's important to make is what is the burden of proof in a particular scenario. Holden said that beyond a reasonable doubt for a criminal action, and this is a very, very high bar to cross, is that if you're going into a criminal action, basically, if it goes to trial, the prosecution has to say it's almost 100% certainty that this was the responsibility of the person who's being accused of this. If there's anything less than that, less than 100% certainty, then it's almost never going to hold up. Whereas the civil action is the criteria is much less. It's basically more certain than not. So if you think it's like 60% that somebody did something versus 40%, that can actually be the criteria that holds in a civil action, which is a much lower burden of proof. So yeah. According to the second resource, what is the Foreign Corrupt Practices Act, FCPA, and why do you think is necessary to regulate how domestic organizations could conduct operations internationally? Dylan, what does your group say on this one?
So the FCPA prohibits domestic organizations so that are operating internationally from participating in things like drives. And we said it was important because the United States has a lot of global influence and US law prohibits those actions. So even if there are countries that allow bribes of officials, the United States thinks that if the company is originating out of the United States, they should abide by the laws wherever they practice.
Right. And so that was kind of the whole goal of the Foreign Corrupt Practices Act. And we're going to delve a little bit deeper in that in a second, because there's some very interesting recent developments in the FCPA. But the idea being is that businesses operate differently across the world. And one big business practice that's frowned on in the United States, it's considered to be illegal, is corruption or bribery. All right. And so if you conduct that business in the United States, that could be a violation of law, and you could be found guilty of that. But if you're a U.S. business that's operating internationally, there could be an expectation is like if you want to actually have approval of your business doing work in a particular jurisdiction, then you should bribe the official who's in charge of approving that. That is an established business practice in other countries. So if that's not something that's allowed in the United States, but it is allowed internationally, what is a U.S. firm to do? And this was the answer to that. It said you're supposed to act as if you were in the United States, that your rights and responsibilities are consistent with that. So that creates a little bit of a problem because a lot of businesses are considered to be at a competitive disadvantage if they operate that way. And that was actually one of the statements that was made in the Fraud Examiner's Manual regarding the Foreign Corrupt Practices Act. And that, again, that's been something that's been a big argument. And like I said, recent developments in that have kind of shed some light on what a lot of the businesses think about the Foreign Corrupt Practices Act as it works in reality. We'll get to that. Let's move on to question number 4. According to the third resource, what are the 4 types of evidence that can be used in a criminal case, and briefly define each type? Colin, what'd your group say on this one?
Real evidence is any physical evidence such as DNA, weapons, fingerprints, or like piece of clothing. Demonstrative evidence, diagrams and charts that work in conjunction with the witness's testimony, such as like crime scene diagrams or maps. Documentary evidence is used during trial to prove or disprove allegations, and documents must be trustworthy and authentic. And then testimonial evidence or eyewitness testimony referring to a person who saw the alleged crime and was willing to share their side.
Good. All right. So real evidence, basically physical evidence, things that a jury can see and touch during a trial. Although I don't know that they want to be touching DNA. That's just weird. Yeah, but demonstrative evidence, diagrams and charts, they usually are in conjunction with witness testimony to provide some sort of direction. Documentary evidence used during trial to prove or disprove actual allegations like newspapers or contracts, letters, diaries, all types of documents that are in courts. But there is a criteria on documentary evidence about their trustworthiness. They do have to be authentic and trustworthy, and that has to be a criteria that's met in order to be permissible in court. And then testimonial evidence. Testimonial evidence is something we're actually going to talk a little bit more about next week about the different types of testimony that can be reached. But person who saw the alleged crime or willing to tell the story, or we can actually talk about people who actually have insight as to the nature of the crime or the nature of the issue and can provide expert insight as to what's happening in a particular scenario. We've seen this in court dramas and court cases, which is fascinating because that's kind of what a lot of us think about when we think about laws. So what do we see on TV shows like Law and Order, or I don't know, what's a more recent one that I'm missing? Have anybody watched some of the crime shows on their TV now? Like what's a good one that I'm missing? Law and Order is the one that jumps to mind because I'm old, and so I want to say it was like I think there's some more like recent ones, like some nightly TV shows that are in law, like Boston Legal. That's a really old one too. I'm really old, guys. You help me out here. I don't watch much TV anymore. I don't know what's on the tube anymore. My mother, she watches like all these crime dramas, so you think I'd know better, but you know, there's always those are always more about the analytics rather than the crime itself. Okay, we are going off the rails here, but yeah, we talk about those TV shows. You noted they sit down in the witness box and they have to swear under oath, and they actually it's like I promise to tell the truth, the whole truth, and nothing but the truth, so help me God. That's kind of the standard that we've met. Yeah, so we'll get back to that. Let's go ahead and move on to question number 5. All right. Consider the 3 categories of occupational fraud: corruption, asset misappropriation, and financial statement fraud. For each category, identify which legal system from question 1 you think would be the most effective and which you think would be the least effective at prosecuting the fraud. All right, so AJ, I'm going to ask you the I think the easier of the 2 questions, which would be the most effective at prosecuting the fraud. So which do you think would be the most effective at prosecuting corruption?
Say common law.
Common law. What was the rationale behind that?
Just because corruption is like an illegal act and it would be the most effective with dealing with it.
Yeah, so if we establish a legal act, then it would probably be once it's established as an illegal act, it's always going to be an illegal act. That precedent really makes it pretty straightforward. Leah, what do you think that would be the least effective in prosecuting? Customary law. Yeah, so I would agree with the sentiment on that. I do think that there's an argument to actually say that religious law or customary law could be somewhat effective. Just if you think about what some of the religious laws and customary laws were back in the day, like especially if we think about kind of the strictest religious approaches to breaking the law. You've heard about some of the countries that had very strict interpretations of law and rule bending, and what was the penalty if you were corrupt? You get your hand chopped off. Okay. And now that's obviously very extreme, and we've kind of moved away from that. But the question is, if that's the case, is that going to be an effective deterrent? Because remember, we've talked about deterrence before, and I've said deterrence itself is not all that effective. But if you had in the back of your mind, it says, if I'm caught on this, I'm going to lose my hand, and I really don't want to lose my hand because I'm really attached to it. Anyway, so would that be effective? And the answer is probably so, but I think that's probably an extreme evaluation as well. I think the better interpretation is that within our modern context, common law would be a better approach to this. All right, what about asset misappropriation? AJ, we're going to stick with you on that. What do you think is the most effective?
We said civil.
Civil law. What was the reasoning behind that?
Said that stealing is wrong.
Because stealing is wrong, yeah. And people can establish that stealing is wrong. Because if we ever establish a scenario that stealing is right, there's a precedent for that, and common law would be less effective. Leah, what'd your group say was the least effective? Customer.
Some cultures might consider stealing to be sharing versus actual theft.
Well, so there's actually some argument for that. Again, if we're talking about long-term perspective, if in modern perspective, yeah, I think we can always say that, yeah, obviously stealing is considered to be wrong in all contexts. But if we go back 1,000, 2,000 years ago, was stealing always considered to be one of those things that was wrong? Like if you got into a war with a raid in a warring clan and you defeated them and you took their goods, was there anything wrong with that? It's like you were by definition the victor, so you could actually pillage and do other things, and that was totally. Now that's horrific in today's context, But that's again where customary law is generally derived from, is that outdated context. So I do think that the definition of what's right and wrong actually is going to be defined by the victor in a lot of those situations. So it's pretty problematic in the scenario where the playing field is even for everybody else. All right, what about financial statement fraud? AJ, what's the most common or the most effective?
We said civil law again.
Civil law. What was the rationale behind that?
Because the financial statement fraud isn't really in the category of common law. We said that civil law would deal with it most.
Okay, I think that there's an argument for either civil law or common law as far as effectiveness. There's like a dividing line, but I would be willing to accept both. And then Leah, I left you with 3 hard questions. What's probably the least effective here?
We kind of all agreed that customary religious were kind of least effective all across the board.
Mhm.
We actually tried to argue that civil would be the least effective here.
Okay.
And I think it was mainly because when we think financial statement fraud it's hard to like make a law to like say exactly like how big of a problem it could be, and like since it could differ so much across different companies.
Yeah, and I think that becomes a little bit of an issue, is that in order to be able to establish financial statement fraud, we have to establish that there's a misrepresentation being made. All right. So by definition, if it's a misrepresentation, then there's something wrong. Okay. Misrepresentation is having something wrong in the financial statements is a necessary condition for a misrepresentation to occur. A civil law would basically say in one scenario, this is a misrepresentation, and this another scenario, this is not a misrepresentation. I don't think you can make that argument, is that you, by definition, a misrepresentation has to be in place in order for a financial statement fraud to take place. So civil law may actually be problematic because there's very, very few scenarios you're going to say it was okay in this situation, but it was illegal in this other situation. So I could actually see that argument. That being said, I don't know that religious law or customary law have the tools or etiquettes to actually be able to address either of these scenarios. So logically speaking, those are going to be the least effective. But out of common law and civil law, I think I could buy into the argument. And I appreciate you going a little bit outside of the box on that one to think about something. Yeah. Whoever was in your group, or if it was the entire group that said we want to mix it up a little bit, kudos to you guys. Yeah, because that's inspiring knowledge right there, is to think about things that aren't necessarily obvious. All right, question number 6. Recall from our discussions over fraud prevention and deterrence that that typically less than 1/4 of organizations pursue criminal or civil prosecution against fraudsters. What is the argument for organizations pursuing criminal prosecution in case of fraud? What is an argument against it? All right, Tyler, back to you. What's your group say on this one?
So for prosecutions, for justice, for people that were involved in those that were affected, again, prosecution would be like it's expensive and hard to find the intent or not enough evidence.
Right. So we've talked about argument 4. It's basically legal action, and it's kind of the whole goal is to be remedial. It's to actually say if somebody did something wrong, then they should be punished for their crimes. Can we also make an argument that that legal action has the intent of being a deterrent? Like if you know that you commit the crime, if you get caught, that you're going to go to prison, is that going to affect your decision? Presumably, okay. Now, ignoring everything that we talked about with the deterrence a few weeks ago, yeah, presumably speaking, if you know that you're going to be punished, like for example, if you thought there was 0% chance of you cheating or you getting caught cheating on an exam, would that increase the likelihood of your cheating? And you don't have to answer that question because I know that's like by implying something, but the answer logically would be yes. Okay, even if you say I'm a perfectly ethical person, I would never cheat in any scenario, that's still going to weigh on your mind. Is that there's literally no chance I'll ever get caught. I always make the joke, Alan Davis, whenever he gave exams, he would leave the room because he trusted his students not to cheat. Okay. Now, there was some risk there because if you did cheat on the exam, like you pulled out your notes and just kind of like saying, well, Dr. Davis is not here, I'm just going to town. One of your colleagues would say, I don't agree with that, I'm going to report them to Dr. Davis. So there's still a risk. But that's something I told him. I said, it doesn't matter if you believe in their ethics or not. If some people, if given the perception that cheating is okay, they're going to do it. Other people will not. But that's kind of the issue, is that the perception of deterrence, the perception of penalty, does actually affect people's operations. At least that's the way it should operate theoretically. Now, Tyler brought up a really good point. Is that argument against is that legal action is time consuming and cost consuming. All right. And it rarely results in recovery what is lost. So especially when we're talking about criminal prosecution, because remember, criminal prosecution is meant to be remedial in the effort, but not necessarily remedial in the actual money that was lost. Additionally, we've already discussed many reasons why fraud deterrence is not effective. What was our biggest argument? It's like, are you going to commit a crime if you believe that you're going to get caught? Like, let's say that you believe that there's 100% chance that you would get caught if you cheated on an exam. Are you going to cheat on the exam? No, I mean, it just doesn't make any logical sense. It's like, I'm going to fail this exam 100%. No, I'm probably going to get like a 54 out of 100 or something. I don't know why I picked 54, but you're going to get an F on the exam. But you know that if you cheat on the exam to prove your grade, that Dr. Caden's hawk-like eyes will pick you out, and she'll say, "Hey, those notes are not allowed." That's a 0. Okay, and a 0 is still better than an F. Okay, it's just a simple quantification. But that's not the way people operate when they commit fraud, is they don't actually commit an action if they believe that they're going to get caught. They assume that they can get away with it. At least there's some chance, at least a better chance than not, that they're going to get away with it. So deterrence tends to be a little bit of a slippery slope. All right, so yeah, we had that, and you probably predicted the direction we're going from here. So I want you to answer the 2 questions again, but I want you to answer for civil prosecution. Did that change the answers? Well, Holden, what did you think?
For the most part, it's a little bit the same, but for the burden of proof is lower for civil prosecution, so it's less costly than criminal investigation prosecution. And then against, typically only monetary damages are awarded, so it makes it less impactful for the prosecutor.
Right. So that's a very interesting point. We talk about civil prosecution of fraud. Civil prosecution tends to be a little bit more focused on, like we said, the actual remediation, whether that be the time and effort remediation. It tends to take the monetary form. There's a monetary remediation, which means there's an incentive. Okay, if you go in criminal action and somebody's found guilty, most likely the result of that is that they're going to go to jail and they're going to suffer a penalty. All right, in a criminal or civil action, if you go into a court and you're found to be the one who wins the case, then whoever was you were suing is going to actually owe you a certain amount of money. So there's going to be some recuperation of cost. Maybe not full recuperation, but some recuperation, at least a significant amount. And as Holden pointed out, I think, Holden, I asked you the question about the legal. I asked you the legal question before, and now I'm asking you the legal question again. That was just happenstance. It was not intentional. But Holden pointed out both times, said that the barrier for proof, the burden of proof, is going to be much lower for civil action. So that kind of gives you an idea of why we have more civil actions typically in this area than we would for criminal actions. All right. ACCT Fraud Examiner's Manual states the FCPA effectively puts companies operating in the United States at a competitive disadvantage. This is actually a statement that was made in the Fraud Examiner's Manual. Do you believe the recent presidential action to pause the provisions of the FCPA support this premise? All right, so I don't really want to get into politics here, but I've opened a can of worms. So Dylan, you are the either fortunate or unfortunate person that gets to approach this topic. So do you believe that supports this premise? And from a fraud perspective, what is one concern you have with the pause in the FCPA?
I think the stated words do support the premise that the FCPA puts the United States at a competitive disadvantage because other businesses that are not out of the United States are able to do the customary practices of other countries. But the risks of the pause, we said, were tarnishment of the image of the United States businesses that participate in these activities, and also the risk of those activities being performed in the United States when they are still outlawed.
Yeah, good. So reading through the pause in the FCPA, there was actually a definition saying about the competitive disadvantage. They talked about that in the issue. That was in addition to another issue that was not discussed here. The FCPA, they talked about the wasted resources for prosecution, is that if you violate the FCPA, then the government agency that catches you, they have to actually spend their time and money and effort trying to prosecute your violation. And even if you found guilty and have to pay a penalty, basically that's all basically resources that are used on the government. And the argument was in the pause in the presidential action is that we could use those resources much more effectively elsewhere. Okay. Now, again, no judgment on whether that's right or wrong. That was just the justification for that. Now, Dylan made a very important point, and something that I kind of agreed with, is that what happens if we pause the FCPA, if we say we're no longer susceptible to the provisions of FCPA? Well, businesses now are going to move into international jurisdictions, and they're going to get used and acclimated to performing in the same way that businesses perform that way. In addition to tarnishing their reputation, if you get used to certain actions taking place as part of an organization, then the jurisdiction may become irrelevant. The corruption may actually become a nature of business that's practical to do in the United States. So these businesses that said, we've got to follow the rules of the United States elsewhere, says, well, now we can operate differently in different jurisdictions. And if what I do in one country is the way that I can get an advantage in the United States, then I may actually take that advantage in the United States. So it's basically, there's a bleed over effect, is kind of the way I described it there. And is that speculative? Yeah, probably. But that's kind of I think that's kind of the concern that with the FCPA had in the first place, is that we don't want businesses behaving inconsistent with the way they should operate in the United States. All right, refer back to the 4 types of evidence that have been gathered in a fraud investigation for week 7. So this is actually section 2 over here. So these are the types of evidence that we were talking about. How closely these types of evidence align with those we identified in question 4? Okay, so you know what, AJ, I gave you the easy question this time, so I'm going to call Leah first and give her the easy question, then I'll give you the harder question. So Leah, how closely do these align? Identically? Okay, all right. And then yeah, like I said, easy question. All right. So do your results suggest the intention of fraud investigations to be gather evidence in a manner that was subsequently used in criminal or civil proceedings? And so I've got two more groups I could talk to. So I'm going to ask both groups. And so Colin, what did your group say on this one?
Which part are we on?
We're in question 9, the second question.
I got that, but what part of the day are you asking?
So Leah answered, how closely do the evidence align with question 1? She said very closely, because that was a very easy question. So now you have to say, do the results suggest the intention of fraud investigation should be gathered evidence in a manner that will subsequently used in civil and criminal proceedings? Why or why not?
Said overall, the purpose of gathering evidence in a fraud investigation should be to prove who's committing fraud. The possibility of criminal or civil cases is a secondary goal, is not an involved goal.
Okay, so that's an interesting perspective, and that's inconsistent with my perspective, but I don't disagree with your statement. AJ, what'd your group say?
We said yes, just because if you're gathering evidence, you may as well do it in a way that you could use it in a criminal or civil proceeding, even if it's not your end goal. It's just nice to have, just in case if you want to pursue that route. Yeah,
and so this creates a bit of a problem, because both answers are correct, and I'm going to explain why. So we know that the possibility of forensic investigation and using a criminal proceeding is certainly a possibility, and something that we should always consider when we're gathering evidence, is that this may be used for burden of proof in a legal action. That being said, what did we say about the consistency of legal actions in the United States with respect to fraud? Do criminal actions occur very frequently as a result of fraud? No, less than 1/4 of the cases. That was one of the examples we talked about earlier. What about civil actions? It's actually even less. Okay, civil actions even less than that. So it's unlikely that even if fraud is found, that there's going to be a civil or criminal action that supports that. So again, one of the goals that Colin pointed out is that to actually determine what's happened in the investigation, what the nature of it is. And optimally speaking, if we find a problem within an organization where the fraud was committed, we fix the problem. Okay. So we know that the fraud occurred. We want to know how it occurred, why it occurred, and prevent that from ever taking place again. And the similar criminal action are going to be on our mind, but they're secondary to the nature of investigation itself. So I think that those are all very valid points to make, and not necessarily easy questions to answer. All right, let's start with the quiz now.
Our group did finance founder sentenced to 4 months for money laundering. But when we read the article, it said 5. So I'm glad you didn't ask that question, because we wouldn't have known. But yeah.
So Binance was founded in 2017. It's founded as a cryptocurrency trading platform that specialized in altcoin, which I guess is any cryptocurrency other than like major ones like Bitcoin and Ethereum. You can still trade Bitcoin and Ethereum on that trading platform, but it specializes in other cryptocurrencies. It basically just provides traders with a cryptocurrency wallet to store all their tokens.
So what happened? Basically, Binance executives had engaged in deliberate and calculated effort to gain profit from the US markets. And they didn't implement money laundering controls that were required by the US. So then the company had a hub for legal financial transactions, and that included extremist groups, criminals, child trafficking, and sexual abuse materials. So Binance failed to report over 100,000 suspicion transactions to law enforcement, that which ultimately led to Binance being guilty to charges of money laundering, unlicensed money transmitting, and sanction violations.
Now moving on to like the parties involved. The first is Changpeng Zhao. I'm sorry if I butchered that, but he went by CZ. He was fined $50 million and then also sentenced to 4 months in prison and stepped down as CEO. Binance was fined 4.3 billion and was one of the largest penalties obtained from a company in a criminal matter. In the article, it also said that he continued to travel around the country like before his sentencing, and that he also announced an online education program. I looked it up and the name is Giggle Academy, which is quite an odd name to pick. But yeah, that's all about him.
So we also included Judge Richard Jones as one of the parties involved. So he was the judge that was overseeing this case. So he offered a lighter sentence because of Zhao's cooperation with law enforcement and then letters that people wrote about his character. Originally, the government was looking to have Zhao go to jail for 3 years, but the defense thought that was too harsh given similar crimes and the punishment for those crimes. So they wanted to find a balance between a deterrent, but then also something that wasn't too harsh. And then kind of like what Maddie was talking about, he was traveling around and because of his wealth, the prosecutors saw him as like a flight risk. So they required him to stay in the US before his like sentencing. So thank you.
The whole bigger group gonna take a stand on whether it's 4 months or 5 months.
It was 4 months.
All right.
How do I move this?
You can go to more. I can do that now. I may have not opened yours.
Yeah, that's
I may have
okay.
that.
Not have you. I sent it at like, I sent it at like 11:10. This one.
Okay. I opened the same one twice, basically. Is that what I did? Okay. Make this easy. Zoom recording. Hide those, get rid of that thing. All right, all yours.
Thank you. All right, we have the Binance money laundering, not laundry.
And for the opportunity, it's relatively unregulated, so, you know, there's not necessarily a lot of rules, so you can kind of do as you please in the environment. And then also it's decentralized, so you don't have someone overviewing all your transactions.
For pressure, Binance was pressured to attract more users and keep their users from using this exchange platform. They were one of the biggest platforms when this whole thing went down, so they wanted to maintain the dominance of that. Rationalization, it was more work to stop the activity. It's unclear which laws apply. We make more by not deterring this activity, and I'm rich, I can pay off. The punishment won't be that bad. Crypto should remain free from traditional banking regulations. So lessons learned.
So what did we learn? We learned if you have a good lawyer, you can get away with money laundering with just a 4-month sentence and a small $50 million fine. It's peanuts to this guy. Cryptocurrencies very slowly, we're catching up. We're putting more scrutiny on crypto and crypto exchange platforms. And if you have money and say you're sorry, you're punishable.
And 50 million was a small fine if you're worth 36 point something billion dollars. So it really was just a bag of peanuts for this guy. But that's it.
One of the interesting things about this case that I've read and I've learned about is that Binance basically knew that they were under scrutiny by the U.S. Department of Justice, and they said we should probably stop, put a stop to the money laundering activities. And they willingly did not do that because they said exactly what Holmes Group says, that it doesn't matter. We've got enough money that they can't really stop us from doing what we want.
That's crazy.
I guess that would be a good position to be in, to have enough money that you can just do whatever you want, but it's kind of a dangerous proposition, I guess.
So we had that Novartis. The key parties involved, it's a Swiss multinational pharmaceutical company. And they would work with doctors to perpetuate this fraud. This is their former CEO. He now works for P&G. And he is an executive officer for them. He has a lot of his other prior employment listed on the P&G website. Notably, this company is not listed for some reason. But he did not face any fines or scrutiny or anything like that. And I'm sure he's living himself a quite lavish life. It's still me. There are 3 different frauds that were committed. Notice on here was not one of the ones that Dr. Barnes put on the quiz. I fell for it, and this was my presentation. So, but they offered kickbacks to doctors for illegal co-payments to boost drug sales. They bribed foreign officials, and they had a price fixing scheme. So they would get together with all the other drug people and set the prices high for people.
So more about the kickback schemes. They pretty much host, they said, tens of thousands of lavish and luxury speaker programs, but they said there were medical expense or medical education conferences. And so essentially they would just invite all these doctors for these lavish meals, experience basically, and in return they would prescribe their drugs so they could get more sales. Those are the drugs involved. I'm not even gonna try and talk about those. And then it was a settlement of 591.4 million to the US government, plus the additional payments for state Medicaid claims.
So the second case involved was Novartis funneling money through charities to cover co-payments for Medicare patients to boost sales of multiple of their drugs. So those were a couple of the ones involved, multiple sclerosis and cancer drugs. And the amount of settlement for this case was 51.25 million. And additionally, internationally, South Korea fined the company 50 million for using medical journals to offer kickbacks to doctors. And there was also a scandal that alleged that Novartis paid Greek government officials for favorable pricing status.
So for other schemes, Novartis committed to bribing foreign doctors to increase prescriptions for medications. Basically, they would just bribe doctors in order to push out their all their drugs that they were selling. That settlement was 347 million. And then industry-wide price fixing scheme, again, trying to put their prices lower so they get more sales. Their settlement was 195 million.
Yeah, that's it.
Yep.
No, leave me alone. I can't. There we go. Okay.
So we have the other half.
So for rationalization, they were acting in the best interest of the company to help it keep it growing, keep it moving. And they were helping patients by allowing them to have more access to medications. And other people in the industry are likely doing the same thing. And then pressure, they were pressure to meet financial targets and to keep high profits. And the pharmaceutical industry is really competitive.
Their opportunity, it didn't really say anything specific, but we kind of just alluded to the fact that they were given the opportunity due to material or control weaknesses and lack of oversight, poorly enforced regulations, and the doctors were also dirty.
So the lessons learned was that you should have strong internal controls so that you, this like wouldn't really be possible to be going on, and like oversight, like as long as the oversight isn't also dirty, because then they could have, you know, stopped something. And that the desire for quick profits and short-term success can just lead to the lapse of judgment and unethical behavior, because in the moment they wanted the money and the trips, but should not do that. And then it's important to have strong leadership, as I said, like the oversight, so good ethical values within the organization. They've now said that they are very committed to ethics and stuff. They have this whole thing that be like super ethical by 2025. So.
It's the ACCT model with committed to ethics stuff.
Yeah.
So we had Cuban.
So basically, this company committed their fraud by inflating their revenues like 1.3 million. And it was all solely from product KAI, which was the Cuban AI, which is really ironic because their AI was supposed to detect fraud, but it ended up committing the fraud. And yeah, Brock will tell you a little bit more about it.
So did this by every advertising pop-up we get, it would search or like basically look at it and see if it was like a fraudulent thing. If it was, it would just block it. And they said they were successfully generating revenue by blocking and not interacting with these fraudulent pop-ups. So doing that, saving money and generating revenue. So that was their 1.3 million. That constituted basically all of their reported revenue for their company in that year. And that was right before their first initial public offering. So on that day, they became aware that of these fraudulent misstatements that were not correct and misleading, but they didn't want to change anything because it was a big day for their company, and they just continued to make those false statements. So it made their company look a lot healthier before this first public offering. And many people saw how well they were doing and wanted to invest. And so their first public offering raised $12.5 million. And then they did another one at the end of the year, and that raised another $20 million. So collectively raising $33 million, basically from inflating their first revenues.
So then some of the key parties involved were Paul Roberts, he's on the far side, so they just go in order. He was the founder, CEO, chairman of the board. He did it all really. And then Joshua Weiss, he was the CFO, and I do not know how to pronounce her name. But she was the head of the audit committee and didn't catch anything. And so the results of the case, Roberts was the only one who pled guilty and was convicted. So he pled guilty to 1 count of security fraud, was sentenced to a year and a day in prison, followed by a year of supervised release. The workforce in the company was cut by 50%. And as of the end of March, they are currently filing for Chapter 7 bankruptcy. So that's it.
Okay, so we have the second half of Vivian, and as AJ mentioned, the software to discover fraud, discover. We're gonna start with opportunities. Essentially, nobody questioned it or investigated their claims, especially the like CFO and audit committee member. They just were like, oh, this is wrong. Okay, we'll support that. So there was really no further investigation into like if anything was actually working. Same goes with like there was no procedures to validate that like claimed software success and performance, so no one was like double checking that like they actually did run these successful AI or AI fraud detection things.
So for pressure, whenever they had their first like public stock offering, the CFO and the head of the audit committee found out about the fraud. And so obviously that was a pressure, so it wouldn't tank their stock price. And rationalization, it was definitely, we knew the test would have worked anyway, so there's no point, and like nothing bad really happened, and we're still making money, so who cares?
For lessons learned, for investing in IPOs, you should really know what you're investing in. So first, you should be wary when 94% of a company's profits and revenue come from just one area of the company. You should also look out for a 678% increase from one full year. In 2019, they only reported $177,000 of revenue versus 1.3 million in just the first quarter of 2020. So that looks a little weird, as well as margins of 90+%. That's also something you should just be suspicious of. And then auditors need to corroborate using other evidence than just what the CEO says, and professional skepticism to not believe when a company says that's what they're doing.
By the way, I noticed that 5 of the 6 group members on the last case were tax track. I did not intentionally assign tax track people a case about auditors, so it's just happenstance. All right, see y'all next week.
Yeah, come on, Travis.